Welcome back to the Constitutional Clarion. In my previous videos about the NZYQ case, I referred to 3 cases where former immigration detainees were seeking to challenge the validity of the provisions that required them to wear ankle bracelets and comply with overnight curfews. Now, the overnight curfew conditions proved particularly problematic to those who could only get work that was shift work overnight. So for them, this has proved to be a real problem. You might remember that originally such restrictions were only to be imposed by the minister at his or her discretion, taking into consideration the individual circumstances and the risk profile of each former detainee, as well as community safety after a rigorous assessment process. At least that's what was explained in the explanatory memorandum, and that's what the original version of the bill said was going to happen. But the bill was then amended due to opposition pressure to provide that the minister must impose these curfew and electronic monitoring conditions unless the minister is satisfied that the visa holder does not pose a risk to the community. This meant that in the absence of any risk assessment at all, or the achievement of the quite high level of satisfaction to the standard that a person does not pose a risk to the community, the default position is that all released detainees are subject to curfews and ankle bracelets, regardless of whether there actually really is any risk to the community. Now, that in turn suggests that the purpose of these conditions is punitive rather than protection of the community. And as we all know, a punitive purpose leads to constitutional invalidity. Clearly, the Commonwealth is worried about the constitutional validity of these visa conditions, and this has been shown by the fact that every time a person has, up till now, challenged them, the Commonwealth Minister has changed the conditions, removing the ankle bracelet so that the proceedings don't go ahead. And that's how all those 3 cases that I referred to previously ended up being withdrawn. It would seem that the Commonwealth does not want to face the risk of another High Court defeat. And frankly, I can completely understand why, given the politics of all of this. But there are now 2 cases on foot which do seem likely to run. The first is the case ASF 17 and the Commonwealth. Now, this involves an Iranian citizen who has been held in immigration detention for 10 years. He failed in his application for a protection visa and is the subject now, of course, of an obligation to be deported as soon as reasonably practicable. However, he has actively frustrated his deportation by refusing to take the steps that are necessary to get him the relevant travel documents. In particular, he's refused to meet with Iranian officials in order to secure the travel documents that he needs to be deported to Iran. Now, he says that he has a good reason not to cooperate, and that is that he is a bisexual, he has converted to Christianity, he is a Kurd, and he has opposed the mistreatment of women by the Iranian government. He says that he therefore fears for his life if he's removed to Iran. The Commonwealth has accepted that there is no prospect of removing him to another country other than Iran. It's also accepted that he cannot be removed to Iran without his cooperation, and that is, quite interestingly, because Iran does not accept involuntary removals. And finally, it accepts that there is no prospect of him actually providing that cooperation. So does this mean that there is actually no real prospect of his removal from Australia becoming practicable in the reasonably foreseeable future, requiring his release according to the doctrine as set out in NZYQ. Well, the Commonwealth has argued that this particular case is an exception to the general principles set out in NZYQ because whether there is a practical prospect of removal must be assessed on the basis that the detainee is cooperating. It contended that when evaluating the prospect of removal of the detainee, one cannot take account of delays caused by the deliberate failure by the detainee to cooperate in his removal, whatever may be the reasons for that non-cooperation. In the Federal Court at first instance, Justice Colvin accepted the Commonwealth's argument. He pointed out that the reasons for refusal to cooperate, including fear of persecution on return to Iran, were matters that were separately dealt with during his application for a protection visa. Once he had reached the end of his appeals on this particular point, he was then being held by the Commonwealth solely for the purpose of his removal from the country. Accordingly, those reasons could not be revisited. The assessment of whether there was a real prospect of his removal becoming practicable in the reasonably foreseeable future then had to be made on the basis of the detainee's cooperation in taking relevant steps, even if in fact the detainee had refused to do so. Now, in this case, the detainee then appealed to the full federal court, and the Commonwealth then successfully sought to remove the appeal into the High Court of Australia so it could be decided there. The Commonwealth seems to think that in this case, it's on a winner. And that is probably because if you go back to the judgment in NZYQ, the court there specifically noted that NZYQ had cooperated in that case. And it said this was not a case of a person in immigration detention having contributed to the frustration of the pursuit of lines of inquiry by officers of the department attempting to bring about the person's removal. The court therefore made clear that the test in NZYQ did not necessarily extend to detainees who frustrate their deportation. As lawyers would say, they distinguished NZYQ from these sorts of cases where there is frustration of the person's removal. So it remains a separate issue that has yet to be decided by the High Court. The decision in this case will potentially affect a much wider cohort of people in immigration detention who cannot be deported because of their own actions or refusals to act which frustrate their deportation. If the High Court were to hold that a person could prevent their deportation by refusing to cooperate and then use this then to force their own release into the community, which frankly I think is an unlikely holding, it would give detainees great incentive to refuse to cooperate in relation to travel documents and the like. The more likely outcome seems to me to be that a refusal to cooperate would not be rewarded with release into the community. But of course, this is a matter for the High Court, not for me. And of course, the court will have to take into account all the detailed arguments that are made before it, which of course neither you nor I are at the moment privy to. Now, the second case is YBFZ and the Minister for Immigration. According to a report in The Guardian, YBFZ and his family fled from Eritrea in 1997 due to religious persecution, and he was later granted refugee status in Australia at the age of 14. He apparently has a criminal record now, which includes the offence of burglary and recklessly causing injury. For that, he was sentenced to 18 months imprisonment, which he served, and his visa was then cancelled and he was sent to immigration detention upon having finished his sentence. YBFZ was one of those who was released from immigration detention as a result of the NZYQ decision. He was later arrested and charged with failing to comply with his curfew on the 8th of December and with further breaches on the 27th to the 29th of January concerning his curfew and failure to recharge his ankle bracelet. His lawyers have sought to expedite the case in the High Court so that it's heard soon, as it will potentially have an impact on others who have been released as a consequence of the NZYQ decision. This case is likely to raise a question about the constitutional validity of both the curfew and the ankle bracelet conditions, which have been imposed upon most of the detainees that were released as a consequence of NZYQ. But it's also possible that it will address the minimum 1-year imprisonment sentences for each day that an offence continues, which even a parliamentary committee, as I mentioned last time, considered was a disproportionate sentence. It'll be interesting to see how the High Court deals with both of these cases, particularly in light of the very poisonous political debate which was sparked by the NZYQ decision. Well, now you're all up to date. Thank you for watching the Constitutional Clarion, and I look forward to seeing you next time. Goodbye.